I want to thank you all for joining us today. We're going to have a conversation with a set of experts about a new process for cost-benefit analysis that's applied to tax regulations. And this new process is being developed jointly by the Treasury Department and the Office of Management and Budget. Essentially, it ends a special treatment that had been accorded to tax regulations in the past. But the tax issues, as you probably know, provide some unique opportunities for analysis here, and unique opportunities for application, or unique challenges for application of the cost-benefit analysis, and that's going to be the topic of today's discussion. I encourage everybody here today to continue the dialogue of this event by sharing your thoughts and observations on social media using the hashtag #LiveAtUrban. You can include the speakers' Twitter handles. They're available on the agenda. I also want to welcome our virtual audience here today who are watching over the webcast. If you have questions or comments, please submit them to events@urban.org, and someone will bring them up to me so you can participate in the discussion part of today. And as a reminder, all the materials that are being presented by our speakers are available on the TPC website on our events page. What I want to do is just start with a little bit of background on TPC and then go on to the session. So, Tax Policy Center, we seek to inject facts and unbiased analysis into the debate over fiscal policy, and we've been doing this successfully for over 15 years. Today, what our panel is going to do is discuss some provocative new work on how cost-benefit analysis should be adapted and incorporated into the development of tax regulations. As I mentioned earlier, this is largely uncharted territory, so there's really a lot to learn. We hope the discussion and your participation will help provide insight and understanding into these new processes. And we hope that policymakers and participants in the regulatory process will use this improved understanding to evaluate the efficacy of the new processes and improve things going forward. We have a great panel today, and I want to just introduce them to you briefly. To my immediate left, Susan Dudley. She's the director of the George Washington University Regulatory Studies Center and distinguished professor of practice in the Trachtenberg School of Public Policy and Public Administration. Susan formerly was administrator of the Office of Information and Regulatory Affairs, OIRA, at the Office of Management and Budget during the Bush administration. Next up, David Weisbach. He's a faculty member at the University of Chicago Law School. He previously served as Associate Tax Legislative Counsel in the Office of Tax Policy at the U.S. Treasury Department. Next up is Greg Leserson, Director of Tax Policy and Senior Economist at the Washington Center for Equitable Growth. Before joining the center, he was Senior Economist at the White House Council of Economic Advisors, and before that, an economist in Treasury's Office of Tax Analysis. And then at the far end, Chai-Ching Wang is Director of Federal Fiscal Policy with the Center on Budget Policy Priorities. Prior to rejoining the center in 2011, she was a senior lecturer at the University of Auckland in New Zealand, where she taught graduate and undergraduate tax law. And so we have this outstanding panel here today. A little bit of background before we start. In April, Treasury and the Office of Management and Budget agreed to a 3-page memorandum of agreement whereby the Office of Information and Regulatory Affairs, OIRA, would undertake a review of tax regulations. If, one, the regulations presented a conflict or inconsistency with other agencies' regulations, or two, the regulation raised novel legal or policy implications, or three, the regulation had an independent effect on the economy of over $100 million. And this MOA replaced a long-standing agreement between Treasury and OMB, where OIRA would only review regulations that Treasury had flagged as significant regulations, basically over $100 million in costs. So we have a new environment now, and that's what we're going to be discussing for the review of tax regulations. And the panel is going to discuss a wide range of things, including how the MOA should be implemented, pros and cons of various approaches, and so on. So without further ado, let me turn things over to our first speaker, Susan Dudley.
Okay. Well, thanks, Mark. So I was administrator of the Office of Information and Regulatory Affairs, or OIRA, And that is the first thing you need to do is know how to pronounce that right. And Mark did. OIRA. So there are a lot of, not OIRA or OIRA, but yes, OIRA. So it's a small office in the Office of Management and Budget in the Executive Office of the President. It was created in 1981, or really in 1980 by the Paperwork Reduction Act, and then Ronald Reagan in 1981 issued an executive order that gave it authority, responsibility for overseeing regulations as well as paperwork. And since 1993, it has been guided by Executive Order 12866. So in my world, these numbers just roll off our tongues. Did I already say by President Clinton? And it was actually almost exactly 25 years ago that he signed that executive order. And if you're really interested in it, and who would not be, we're hosting an event on Monday with former OIRA administrators from the Clinton, Bush, Obama administration, as well as others, just to discuss what its past and its future, and really fun times. So
Sounds
what?
good.
Yes, do come. If you talk to me or talk to Bryce Chenault right there if you want to know more about it. So it's a small staff of policy analysts, and I know its size is one of the things that concerns people. They're policy analysts, economists, statisticians, lawyers, and they provide what President Obama called a dispassionate and analytical second opinion on draft regulations. So I like to say that OIRA staff wear three hats. One is that dispassionate and analytical second opinion, that looking at the costs, the benefits, the regulatory analysis, understanding the consequences, both intended and unintended, both good and bad. The second hat is coordinating interagency review. So coordinating across the government to make sure that policies don't conflict or overlap. And then the third is, because it is part of the Executive Office of the President, even though it is a staff of mostly career civil servants, it is a mechanism for the President to make sure that the policies of all his regulatory agencies that they're responsive to the elected President. So as Mark mentioned, IRS rules have been exempt from OIRA review since 1983. So there was a memorandum of agreement reached in the Reagan administration, and it was renewed in the Clinton administration. And one of the handouts out there was an article that Sally Katzen, who was the OIRA administrator, who wrote Executive Order 12866 and signed that 1993 MOA. She and I wrote in the Wall Street Journal that she characterizes that exemption as being quite narrow, applying to technical rules that interpret discrete provisions of the tax code where the code gives little discretion. And the Wall Street Journal said, like what? And so she added, well, like when the code says days, does it mean calendar days or business days? So that was the original objective of the exemption. And despite that narrow scope and rationale, it has grown into a loophole where rules with very large policy impacts have been considered exempt for review. And I'm just going to give you a few examples. One was in 2012, well, actually several regulations to implement the Affordable Care Act. But in 2012, Treasury worked with Labor and HHS to develop a regulation to exempt religious groups' health plans from the contraceptive provisions of the ACA. Now, we know that was a very controversial and people were very interested in it. IRS said the rule is not significant, it doesn't need OIRA review. In fact, it is so insignificant because we're just interpreting the code, it doesn't even need to go out for notice and comment. Whereas at the same time, both Labor and HHS recognized that it needed OIRA review and needed public comment. I think the tax inversion regulations might be another example, although my colleague Joe and I are going to debate that after this. But I'm going to give you an example when I was OIRA administrator. In July of 2007, the Alcohol, Tobacco Tax and Trade Bureau, not part of IRS, another part of Treasury, proposed regulations that would require nutrition content labeling for alcoholic beverages. They went straight to the Federal Register, did not go through OIRA review. To me, that is it illustrates how this narrow exemption really blew out of proportion, because FDA knows something about nutrition labeling, and it would have been nice to engage FDA in that rulemaking.
I'm sorry, it was all of Treasury rather than just IRS and tax?
It was IRS and tax, but the loophole had been expanded. The other parts of Treasury
But
were...
that part, tobacco tax and trade is actually part of the Office of Tax Policy.
So maybe that's why they thought they could. Okay.
Sorry to interrupt you.
All right. No, I didn't know that. That's so growing concern. The GAO, you probably are all aware of the 2016 report, and I know someone from GAO is here, but I won't call you out. Reviewed dozens of similar cases and said, hey, it's time for OIRA, for OMB and Treasury to revisit this exemption. President Trump last year, he issued an executive order basically saying Treasury and OIRA revisit this exemption, and his GAC, the Senate Homeland Security and Government Affairs Committee, sent letters saying it's time to revisit the exemption and held hearings. So that then led to this MOA that Mark described. So it does require IRS to submit regulations to OIRA for review, the way other agencies do, but it commits OIRA to review them in a shorter time period, so 45 days instead of 90, and in some cases on request to try to expedite review within 10 days. It also requires Treasury to conduct regulatory impact analyses, which is the subject of our discussion today, for economically significant and policy significant regulations. So I think this MOA strikes the right balance between the need to make sure that these regulations are consistent and accountable, and that they have the analysis and coherence that I think is important for major policy decisions, but also that it recognizes the tight time frames that tax rules have to be issued under. So I have a few more minutes, so I'm going to just run through some concerns that I've heard, and I'll tell you what I think about them. So the first concern is that IRS rules merely interpret the tax code so that any effects stem from the law, not from IRS. I think that's hogwash. Every agency's rule all their regulations stem from statutory authority. So that one I'm just going to brush aside. The other ones I think are more reasonable and meaningful. One is the delay that OIRA review might introduce. And it is true, sometimes if you look at the review times, sometimes OIRA takes a long time to review regulations. They have up to 4 months, 3 months with an extension. But I think the MOA recognizes that, and I think the MOA has resolved that. And in fact, I've looked at the regulations issued so far, and all of them seem to be done within 10 or so calendar days, 15 calendar days, 10 or so business days. That's for the rules under the job. What is it? The Tax Cuts and Jobs Act. That rolls off your tongue and not mine. The other concern I've heard is that it's going to be hard for IRS to develop these regulatory impact analyses. They look at EPA and OSHA and some of these other agencies' 1,000-page RIAs. And yes, I understand, I agree that would be hard, but I think those are the wrong template. A more likely role model would be HHS, so regulations that transfer money from the FISC to health providers or, say, food stamps. That's a much more similar, those regulations are a lot more similar, and if you look at those RIAs, much shorter, much less focused on a full-blown benefit cost analysis and more on how cost effectively can we do this? How can we minimize that excess tax burden and the unintended consequences? I'm going to quickly go through this. The other one is that the OMB staff size is small. It's 50 people, 50 career staff. And it is small, and they will have to hire a few, and indeed they have. But it would be wrong to think that they had to hire another whole batch of tax analysts. What OIRA should be bringing is a different perspective, and I think that they do. So go back to the 3 hats that I have. So OIRA will bring that coordination, which could be very important for the policy implications of these rules. Bring good regulatory practices. OIRA staff, they're regulatory experts. They've got the statistics, they've got the regulatory analysis, and they know the regulatory practices. So I think what you might see is they'll be teeing up issues for public comment, making things more transparent so that the public can weigh in on different alternatives, and requiring Treasury or IRS to to justify the alternatives that they've chosen and present some different alternatives. So I think that cross-cutting expertise in regulatory analysis, law, statistics, economics will really bring a lot to the IRS rule process and make the rules better thought out and better outcomes. And I'll stop there.
Okay, thank you. Next
I
up,
have slides. I don't know
David's
how
got some slides, and we have a clicker for you. Get the technology to work. There you go.
I'm sorry? Oh, there we go. Great, thank you. All right, thanks. Thanks for having me. So, as Susan just said, the MOA subjects certain tax regulations to this Executive Order 12866. And the standard, just to be clear what is subject to it, there's three things. The most important one, which is what requires the quantification, is if the regulation has annual non-revenue effects on the economy of $100 million or more. Right, that's the standard that we're dealing with. So I don't know how many regulations will meet that. We'll have a discussion, but that's the rule that's there. And if you meet 12866, if you meet the 100 million, you got to do a quantification, and then the rule in 12866, which is found in 12866-1A6, I guess that is, which is each agency has to then justify the action they take by a comparison of the costs and benefits. And it's a somewhat ambiguous language. It's important to note. It doesn't say the costs have to be less than the benefits, or you have to maximize benefits over costs. It just says you have to justify it based on the cost of benefits. I think it's important for tax because in taxes we'll talk about other issues come in like distribution. Okay. All right. So what is the challenge in adopting this to tax? So it's one thing to say Treasury shouldn't have this special exemption. It's something to say, well, how are we going to do this? And the reason why it's difficult is what Treasury does when they issue tax regulations is really different than what other agencies do. So here's the first challenge. Circular A4, which is the document issued under the Bush administration, I believe. Did you draft that?
No.
No, okay. Says that you're supposed to ignore transfers when doing cost-benefit analysis, right? And I have the logic up there on the slide, but the basic idea is that cost-benefit analysis is supposed to measure changes in real resources, and transfers either amongst citizens or residents or between people and the government don't change the total amount of real resources out there. And it then says just flat out taxes are transfers. And if you then follow that logic, you get to the conclusion that there's no cost and benefits of a tax regulation other than the administrative costs, in which case every tax regulation would fail cost-benefit analysis unless it reduces administrative costs or compliance costs. Right, so the first challenge is how do we think about that? We're interpreting Circular A4, and the way I want to think about that is actually not all taxes are just transfers. Right, some changes to tax regulations actually change real resources in the economy. Right, and so the goal in interpreting A4 then is to think about how do taxes change real resources and isolate that piece and treat transfers separately. The second challenge with doing cost-benefit analysis for tax is that most regulations done by other agencies aim to, if you will, internalize or fix externalities, right? And therefore, raising revenue is not a key concern, right? And the distribution is thought to be secondary because, well, we have the tax system to handle distribution. So the standard cost-benefit analysis tends to focus on whether the regulation does a good job of internalizing externalities. And tax is really different, right? Most tax regulations are not about externalities or market failures. They're about raising revenue. And distribution is a first-order concern because the tax system is designed the way it is to raise money in hopefully a fair way. And so the standard tools of cost-benefit analysis may have a hard time with tax. So it's one thing to say taxes shouldn't be special. It's another thing to say, well, how are we going to do this? It's going to have to be done maybe somewhat differently than for other regulations. Okay. All right. So I published an article in Tax Notes, which I think is handed out today, that tries to identify a way of dealing with these problems. And I have two co-authors at the University of Chicago, Daniel Hemmel and Jen Now. And Jen was in OIRA under Obama, I believe. Okay. And so here's the idea, which is that we identify the component of tax regulations that is not a mere transfer, that affects total resources available in the economy. We separately identify that. That's this thing we call the marginal revenue rule. And then we state that as part of the cost-benefit analysis. And then also in an RIA, we would separately state the distributional effects of a tax regulation, which A4 already requires. and separately state the revenue effects, which is not part of A4, but we think should be also part of the RIA. Okay, so what's the marginal revenue rule? How do we identify the change in total resources available or created by a change in a tax rule? And this could be a regulation, it could be a statute. What we look to is a piece of the economics literature known as the elasticity of taxable income, which is a pretty well-developed approach in the economics literature. There's some sites there, stems from Martin Feldstein's work in the 90s and goes up to recent work today by Joel Slemrod and McKean. And here's the basic idea of the approach. We'll use an example to think about it. Right, so imagine we just have an individual who's deciding how much to work, and the individual can earn, just to have a round number, $100 an hour, and is subject to a 30% tax. And these numbers are just rounded so we can do the math in our heads. Right, so the individual then keeps $70 for every hour he works after tax. Okay? Now the question is how much the individual works or decides how many hours to work, and the answer is the individual will work enough so that an extra $70 from one more hour work is just equal to the cost to that person of giving up free time. Right, so you can go to your kid's baseball game, or you can work a little bit more, and you balance those two things, and when the cost of the baseball game is $70 and the benefit of work is $70, you're perfectly balanced. You're kind of indifferent across these different choices you can make. And sort of the basic setup and sort of a standard economic framework of how people might maximize. Okay? Then the question we ask is what happens if you change the tax rule so that the person works one more hour? Right? How do we think about what the effects of that are? Now, if the person works one more hour, the person is no better or worse off, right? He was previously balanced between the extra hour of work and the extra hour of free time. So he's kind of indifferent between the extra hour. He's no better or worse off because of that extra hour the person's made their work. But guess what? There's $30 more, I should say, in the economy, right? Because he earns $100, he keeps 70, but has reduced free time, so those offset. But there's $30 more in tax revenue, right? So by making that person work an extra hour more, what we've done is increase the resources in our society by that extra $30. And what the marginal revenue rule says is that piece there is the efficiency benefit of the regulation. Okay. Now, you can do the same thing if the person works an hour less, right? You have $30 loss, right? Works exactly the same way. And you can also add in compliance administrative costs. If the person has to add, say, keep records, or it gets to reduce the amount of records, those are pure costs and benefits to society. So if the regulation requires the person to spend an extra $100 on compliance costs, that's just a loss to society, if you will. And so we subtract those out, right? Or we add in reduced compliance and administrative costs. And that's the total rule. Here's the rule, right? The change in resources available to society from a regulation is equal to the change in tax receipts due to behavioral changes, minus any increase in administrative or compliance costs. And then I add in at the end, if the regulation happens to be something like, I think you mentioned regulations that had externalities, what was it, the contraceptions or something like that. You might say any other normal cost benefit piece that would go into it. Okay, that's the rule. And you can show, in fact, that it extends to a wide variety of situations. So not only hours worked, but basically any element of taxpayer choice. It could be reporting or not reporting, working in the informal economy versus the formal economy. It could be sheltering, shifting across tax bases. The same basic approach you can show extends to sort of a vast variety of situations that might be covered by tax regulations. It also extends to discrete choice, where you can either work or not choose the number of hours you work. As long as there's enough people out there that you can model the economy essentially as a continuum of workers, it extends to that case as well. Okay, so it's a pretty broad approach. We think it measures the total resources available in society, or the change in total resources from a regulation. What about transfers? Right, so lots of people won't change their behavior. You change the tax rule and they pay more, pay less in taxes. Those are pure transfers. Well, those don't change total resources, so under Circular A4, those are kind of netted out and not part of the standard cost-benefit analysis. Right? If you pay more money, but you don't change your behavior, you're worse off by that amount of money you pay, and the government's better off, and those just kind of net. So we net them out. Okay. Keep on going. Now, a key piece in tax law and tax regulations or tax economics is what about distribution? Right? We have the tax system we have, an income tax, because we care very much about the distribution of the tax burden. right? Who pays matters. Now, how do we deal with that? Well, there's, I think, two basic ways you might deal with this. One is to say, well, we weight the costs and benefits of a regulation by who pays, right? If a rich person pays, it might cost them less than if a poor person pays. So you might have some kind of weighting in this formula. Or you might simply say, well, we'll just give the pure cost-benefit analysis, how much resources change, and separately state the distributional effects, right? And I favor the latter. I think that's clear, provides more information, and doesn't cause Treasury or OIRA to embed distributional assumptions into the analysis. Instead, they're separately stated as, here's what the effects are, you just present a table. So my view is separately stating distributional effects is a better way of doing it than trying to weight the costs and benefits, but that you need to include the distributional effects in any RIA. And Circular A4, this quote, already requires this. Okay? There's my rule, right, which is Treasury should supply three pieces of information, right? The change in total resources available using the methodology I just described, which we call the marginal revenue rule, but call it whatever you want. Separately state the revenue effects, right, which that includes both the change in total resources and taxes that are just paid because of transfers, and the distributional effects. Right, each one of these is important, each one should be separately stated, and the RIA should include all of these. And let me add one more thing before I finish, because I've got 1 minute. I think Treasury, to a great extent, has the ability to provide this information. So here I'm kind of in agreement with Susan, which is they have economists that for legislation already do revenue estimates and distributional estimates. And the top piece, number one, the change in total resources, can be simply derived from the second two. Right, and so I think Treasury has the capability of doing it. They don't currently do it for tax regulations, they do it for legislation, but using a similar methodology and extend that to regulations. I think that might require economists to be involved in the early stages of reg development, maybe some additional staff at Treasury to do that, but I think the resources are already there to make this happen. Thank you.
Okay, thank you, David. Next up, Rick Learson. You have slides too?
Yep.
Okay.
All right. Well, thank you, Mark. Thank you to everybody at the Tax Policy Center for organizing and hosting us today. Like David, I'm going to be talking about this question of how Treasury should conduct cost-benefit analysis of tax regulations. And you know, as people have already stated, tax regulations in the past traditionally have not been subject to a formal cost-benefit analysis. And when we think about tax legislation in the running through Congress, we also typically don't evaluate that through sort of a cost-benefit framework, at least not in an explicit fashion. And so all of that might suggest that we need sort of a fundamental rethink of how we evaluate tax legislation and regulation to do the cost-benefit analysis. But in fact, the traditional tools of tax analysis are exactly what we need to evaluate the costs and benefits of tax legislation or tax regulation. And so the task before us is really to translate those traditional analyses into the language of cost-benefit analysis and understand what they're delivering for us. And if we adopt that translation perspective, right, it also emphasizes that there are certain questions that tax analysis has not traditionally been understood to answer. And so if we adopt this translation perspective and realize that the underlying economic issues are really the same, the underlying research and parameter estimates that we're going to use in this analysis are really the same, we should expect those limitations of traditional tax analysis to carry over into the cost-benefit analysis. There are certain questions that we have not traditionally answered, and adopting the cost-benefit perspective doesn't mean we can suddenly answer them. And to sort of put a finer point on that, in the tax debate last year, Joint Tax produced an array of estimates of all different types, revenue estimates, distribution estimates, macroeconomic analyses, right? But Joint Tax didn't sort of summarize those and say the net social benefits of this legislation will be $50 billion, or the net social costs of this legislation will be $50 billion. And I think that's entirely appropriate, and sort of as we shift the responsibility in some sense for this analysis from JCT to Treasury and say now there is a cost-benefit analysis, we shouldn't expect that analysis to answer this question without making some set of assumptions that wasn't made before. But in fact, I think it's appropriate to make the same assumptions we had before when doing these analyses. So what do I mean when I say the traditional tools of tax analysis are the appropriate tools for cost-benefit analysis? Well, if you think about the fundamental trade-off in taxation, I impose burden, I impose compliance costs, and I do that to raise revenues. And we can think of the burden and the compliance costs as being akin to the costs of the policy, and we can think of the revenues as being akin to the benefits of the policy. And if I phrase it that way, it's clear that this is sort of the bread and butter of tax analysis, that distribution tables exist to provide us with burden estimates, and indeed that's a core similarity between what David and I are saying here is the justification of burden estimates based on fixed behavior assumptions. I'll get to that a little bit more in a minute. We have revenue estimates, which hopefully give us an estimate of the revenue impacts of legislation or regulation, and compliance cost estimates which are not as prominent as revenue estimates and distribution estimates, but Treasury has produced them in the past for regulation and certainly can produce them more in the future going forward and become sort of increasingly prominent in the regulatory context. That's sort of the third piece we need for this analysis. And so if we take that perspective and we say what we need, the trade-off in taxation is I impose burden and I impose compliance costs to raise revenues, and I have these three tools that will give me estimates of each of those pieces, then those results are exactly what the cost-benefit analysis should report. It should report burden, it should report compliance costs, and it should report revenues. Now I want to emphasize there's often sort of a sense that revenue estimates and distribution analysis are a little bit paint by numbers, that the real economic analysis occurs elsewhere. And I want to emphasize that that is exactly backwards. We can think of revenue estimates and distribution estimates and burden estimates as being what we really want to evaluate changes in tax policy, whether it's legislation or regulation. And all of the rich complexity of your analysis ultimately feeds into these two products. So as an example, you may have a set of incidence assumptions that you traditionally use in your distribution analysis. But you may have a particular piece of legislation or regulation which has complex effects that you don't think your traditional assumptions sort of work or allow you to operationalize. And so you may go into a detailed analysis of sort of how you think this policy will affect prices. Prices are ultimately what an incidence assumption is. So when we think about how does this change in tax affect people, we all sort of know that the people legally obligated to pay the tax may not be the people who actually pay the tax. That's the incidence assumption, and that reflects a change in prices as a result of the tax. So you may have a complex economic analysis, but that's all going to feed into revenue and burden estimates at the end of the day. And so those are sort of what we want, but you may have 200 pages of analysis in a complex rule to get there. You may have 2 pages of analysis in a simple rule to get there. But those are sort of the quantities we want. So how do we contrast that with sort of what we might expect a cost-benefit analysis to do elsewhere, right? Well, a sort of, in classic form, a cost-benefit analysis quantifies social benefits and social costs. And so in this framework, those social benefits and social costs translate burden and translate compliance costs into social costs, and they translate revenues into social benefits. This is exactly where sort of the economics no longer can really help you. The translating burden estimates, which are sort of disaggregate impacts on people throughout the population, into an idea of social cost, requires me to take a stance on the appropriate distribution of the tax burden. And I can help you think about that question. If you sort of give me a set of preferences, I can implement those preferences through policy in various ways, but it's not solely an economic question what the appropriate distribution of the tax burden is. And so I can't translate a raw burden estimate, which is the economic quantity, into this aggregate social cost without taking that stance. On the revenue side, again, normally there's probably at least a few people in this room who grimaced when I said revenues are akin to a social benefit, because when we do cost-benefit analysis, we say, oh, ignore the financial flows, look through to the quantities. Welfare is about quantities. So it is, what are the revenues spent on? Maybe it's 5 miles of additional interstate, or maybe it's used to reduce taxes, and that's a reduction in burden. And so then I evaluate the social value of revenues based on their use. But in the case of a tax regulation or tax legislation, the use doesn't occur at the same time. And so any sort of assumption about how we value those revenues is either you can think of it as sort of an assumption about policy that has been yet to be specified, or it's an assumption about sort of your subjective value of changing the revenues available to the government. Neither of those is really something that as an economist I can give you, and there's a little bit of tension between either of those quantities and sort of the traditional idea of what scoring does. Scoring sort of takes as given the policy change, whether it's a legislative change or a regulatory change, and says that happens, nothing else about federal policy changes. People may change their behavior, states may change their behavior, foreign governments may change the behavior, but this change in policy is the be-all and end-all of policy, and then we evaluate that change, right? And so that's why we don't necessarily, we can't necessarily sort of fill in what happens from these pieces. Okay, now I say that you know, this should not be done as part of your formal cost-benefit analysis, but absolutely everybody, you know, the public, the policymakers should be using the results of the cost-benefit analysis to make these judgments. That's sort of exactly achieving the transparency and the accountability function that we would expect of these documents. And so, the core of what I'm saying is absolutely use the cost-benefit analysis for these purposes. Use it to make these judgments, but don't include those judgments in the economic analysis per se, as those require sort of additional judgments. Okay. I'm going to here free ride to a substantial extent on David's presentation, because this portion of our analysis is really entirely the same in an important sense. And this is sort of, you know, we're all sort of familiar with revenue estimates, but we may be less familiar with thinking about distribution tables as impacts of burden on, you know, sort of as measures of burden changes. And the reason we can sort of think of them that way is precisely this idea that David was explaining about people being indifferent in the baseline between slight changes in their behavior, that they're optimizing, that they're doing the best they can for themselves. And so as a result of that, when we do a distribution table and we say what really matters here is the direct change in tax, that's what matters for welfare, that's exactly the same point that David was making of sort of we don't need the sort of the direct impact of the behavior on the public is not what we need just for welfare evaluation. That part we can ignore, but we do need the change in taxes that results because I changed the rules and now your tax payment changes, and you very much care about that. Okay, so this is a result that exists under a set of benchmark competitive assumptions that economists tend to use. There are a million ways it can fail, and I am not going to run through all of them right now, but you may well need to adjust your distribution and burden analysis if any of these failures occur, and these can be things like externalities, market failures. There's also sort of a special class of reasons it could fail if your policy change is large in a certain sense, and all of that are sort of reasons they may need to change. And finally, we can think of compliance costs as being an adjustment to the sort of burden estimate that we typically abstract from in legislation just due to the scale of these changes. But in the regulatory context, the compliance costs will often be first order. And so you'll want to incorporate these in some sense into your burden analysis. You can think of that as separately. You can think of that as being a direct modification to the distribution table. Okay, so I am going to wrap up there and skip baseline and economic significance and just step back to sort of the bottom line summary here, which is that the fundamental trade-off, the costs and benefits we're comparing when we do taxation is that we impose burden, we impose compliance costs to raise revenues. And that's exactly what the cost-benefit analysis of tax regulation, or equivalently cost-benefit analysis of tax legislation, if you were to do it, should be focusing on. But under this approach, we should not be quantifying social benefits and social costs, precisely because that would require us to take a stance on the appropriate distribution of the tax burden, and we should leave that to policymakers and to the public outside the formal context of the economic analysis, and we should not make assumptions about policy changes that would allow us to fill in social benefits of revenues in a direct fashion in the way that sort of economists traditionally would. So I will stop there, and thank you very much.
Okay. Te-Ching, you want to back clean up here for this today?
So I'm going to focus on the question of how should this process deal with that looming question of distribution and revenue. And I'd like to try to add 4 things to the conversation. First is the very fact that distribution and revenues, these things that have been bucketed as transfers, have been set to the side in cost-benefit analysis in other regulatory areas, is precisely the reason it has to be central to analysis and tax. Second, what does that actually mean for the target of cost-benefit analysis or the regulatory impact analysis and tax? And my contention is that specifically impacts of tax regulations on the size of government and redistribution should really, centrally and very transparently factor into the information that's being presented in the framework for tax regulations. And to sort of draw a distinction, that's not the same as saying that the cost-benefit analysis or the regulatory impact statement should take a view on the appropriate size of government or the appropriate level of redistribution, and in fact, they should transparently avoid doing so as assiduously as they can. Third, I'm going to try and compare a little bit the two approaches that we've just heard, how they're similar and how they're different in relation to that target. And finally, I think I'll just sort of return a note that appropriately addressing this question doesn't deal with some other looming first order questions that, in my view, we can't actually just brush to the side. So first, the way that cost-benefit analysis has been set up in other areas of regulation really, in my view, makes it much more critical for cost-benefit analysis, regulatory impact analysis and tax regs to centrally and transparently account for what 12866 calls redistributive impacts and equity. That EO sets maximising net benefits to the American people as the ultimate target for regulation and requires taking into account distribution impacts and equity when doing so. Now, distribution impacts equity in this context can capture two concepts that we've heard a bit about. First, the fact that a dollar in the hands of a private person may not generate the same welfare in the hands of government for the provision of public goods and other things that government does. And secondly, a dollar in the hand of one private person may not generate the same welfare as in the hands of another private person. So if you're trying to maximise social welfare, you need to take into account that a dollar for Warren Buffett is not going to generate the same value as a dollar for a low-wage worker, which may not generate the same value as if that dollar was spent on infrastructure or the public defence or et cetera, et cetera. So in practice, a key weakness, I think, of cost-benefit analysis from the outset in all other areas has been that a lack of distributional analysis that takes into account these transfers between private people and between the public and the private sector. For other areas, 12866 requires that consideration, but in practice it has sort of fallen out of the cost-benefit calculation and been put to the side. Now, one argument for that in the academic scholarship from Kaplow and others in that vein is really that you can do this because, when you're thinking about those other regulatory areas, pollution, health, whatever it is, the tax system will take care of all that. The tax system is going to be the system that takes care of those revenue goals and those redistributive goals. So you can ignore those things as transfers and we'll take care of it over here. So your regulatory impact statements can focus on Kaldor-Hicks efficiency, and those tax people and the fiscal system over there will deal with everything else that you need to actually get to the Pareto optimum. So that's kind of the approach that's been taken, and there's plenty of criticism one could make about that approach. I won't sort of rehash all of that here, but that's really how we've ended up with the system as it's been set up. But even if you are convinced by that approach, of course, if regulatory impact statements, the cost-benefit analysis and other areas have sort of set redistribution and the size of government to the side because tax is going to deal with it, then that really means that the one place you can't ignore it is when you get to doing these statements for tax. And just as an aside, as a sort of I guess, a defensivalist, a tax exceptionalist. This is not tax people saying we're special here. This is actually something that's been foisted to tax through the system of regulatory impact analysis in other areas. And even if you were to sort of ignore the system as it's been set up to date and just sort of approach this question afresh and really just ask, what role does the fiscal system that gives rise to tax policy and tax regulations play? You'd get to a similar answer, because of course a really core function of the tax system is to not just enhance efficiency in a narrow sense, but to raise revenues for public goods and to redistribute. So both in the way that the regulatory impact analysis system has been set up and because of the purpose of the tax regime, the buck really stops here in tax in terms of those two key issues. So I think that's the target that's appropriate here. These cost-benefit analyses really should clearly and transparently explicate the way that tax regulations could impact revenues and distribution, and in that way really sort of start grappling with these issues that have been left to the side. So now I'd like to sort of turn to how I think there are similarities and differences between the two approaches that we've heard so far deal with this question. They're operating, as we've heard, in really the same basic structure. In their framework and in the framework that Clint Wallace in his paper has also proposed, cost-benefit analyses really have to examine the revenue impact of tax regulations. It just makes no sense to put that to the side as a transfer when you get to this area. That's not much of a surprise. As Clint Wallace says, it's kind of bizarre not to. So to that extent, they're in a similar set of frameworks. And to recap, David says, along with his co-authors, that for the purpose of tax regulations, the marginal revenue calculation, a revenue rule calculation, should assume really that the social value of $1 in government's hands is the same as the social value of that dollar in a private person's hands, and then set redistribution to the side, provide the distributional tables, but not factor that into the MRR calculation. Greg says, set out all the same components of that analysis, revenue analysis, distribution analysis, the compliance and administrative costs, but he argues that you shouldn't include a calculation that on the one hand assumes one set of normative weights and computes a bottom line, but on the other hand is not yet a complete social welfare analysis. So I think between the two, where I come down is that I prefer the approach of not adopting a calculation that assumes weights for two reasons. The first is that one might look at that marginal revenue rule calculation and say, well, this really just looks very much like an efficiency analysis of the sort that we do in other areas of regulation. As we've heard, Professor Dudley suggests that actually something like that efficiency calculation should be the target in tax regulations. But even if that were the right way to think about the MRR rule, for the reasons I started with, I don't think in tax, unlike in other regulatory areas, we should be attempting to do an efficiency calculation that sets distribution to one side, given the core motivations of the tax system and the way that the analysis of regulations has been set up in other areas. We can't ignore those public goods and redistribution aspects across all regulation, and so when you get to tax, it's not desirable to try to start with or sort of centre some narrower notion of efficiency. And second, even if your target were just an efficiency analysis, while the marginal revenue rule is not a full welfare analysis, it doesn't avoid normative questions or problems that you run into when you do the welfare calculation either. The calculation, as I mentioned, weighs $1 of revenue in public hands the same as in private hands, which means, and as David and his co-authors acknowledge, it embeds a very strong normative assumption about the right size of government, there being no welfare gains from making it smaller or larger on the margin. We can have, again, lots of arguments about whether or not that assumption's correct, but David and his co-authors say you can actually put those disagreements to the side. There's another reason for adopting this default, even if you think that value is wrong. For example, they say that it's one way of being agnostic about the right size of government and the right weight, ratio of weights of that dollar in public and private hands. But for me, not knowing the right answer to that question doesn't mean that choosing a particular value for that weight is agnostic. In fact, I don't see that there's a particular justification for picking the value of 1 as opposed to 1.5 or 0.5 or any other value. So I think picking any specific ratio at all really means you're no longer being agnostic or potentially as transparent as you could be, that is really a normative question that policymakers and others like myself and other people here can argue about. So there are other institutional concerns that David and his co-authors raise about protecting Treasury and OIRA from having to make these normative judgments. I actually think those concerns are really important and valid and deserve a lot of attention. But to me, they point in the direction of laying out all the pieces of the calculation and not trying to do any part of it that embeds a particular weighting. And finally, I think perhaps we can pick this up in discussion because I've run out of time, but the one question that none of this really deals with, of course, is one that Professor Dudley raised earlier, which is the question of when does this entire framework make sense? It makes sense when a regulator is, in some sense, optimizing between a set of alternatives that it can choose. And there is still that lingering argument that even when a regulation is implementing a really big policy change, there are some circumstances where the law as a code drives towards a result where there is no alternative. So in that case, when you're doing a cost-benefit analysis, all you're really doing is a de novo assessment of whether or not the underlying law is sound. So that question still has to be grappled with on a law-by-law basis and a regulation-by-regulation basis, and these frameworks don't necessarily provide an answer to that question.
Great, thank you very much. We're going to have a little bit of discussion among ourselves first and then open it up to questions from the audience. I want to remind the folks who are watching via webcast, if you have questions, send them to events@urban.org and we'll get them into the mix. I just want to follow up on Chai-Ching's endpoint. It was actually a great lead-in for her discussion. We've had a few examples of regulations going through the process where OIRA does the review. Probably not enough to generalize and say this is going well, this is going badly, this needs to be fixed or whatever. But the question that Chai-Ching raised, I think, is an important one. If we look at the MOA, do we envision that what the analysis will do will say, here are 5 possible interpretations of the statute. We considered each one of those. Here are the costs and benefits of each. And look, we chose this one because the costs exceed the benefits by the largest amount. Or the flip side of this is, do we look at the process as there's exactly one answer to that statutory set of words, and this is the way that it needs to be interpreted. And so what do you think, Susan, is the idea behind the MOA? Did they really, the authors really think there'd be several options and that each would be evaluated separately and then discussed in a public document and said we chose this one for the following reasons?
I think so.
Mm-hmm.
So I think at least a lot of the regulations will have different ways of interpreting the statute, and also within the flexibility that the statute has given different approaches. So I want to just step back and say a regulatory impact analysis required by Executive Order 12866 and the Circular 4 that you mentioned is more than a benefit cost analysis. That is one piece. But the first step is always, why are we doing this in the first place? And David's right that that's usually a market failure question. Is it an externality, natural monopoly, et cetera? The second step is then look at different alternatives that can achieve that need that you've identified. And I often think that is one of the most important parts about an RIA, is thinking through the different alternatives and then doing that. If I do this, then the following things might happen. Both intended and unintended things might interrupt it, and this is how we'll achieve the outcome that I've decided that I'd like. And so that analysis of those alternatives does include benefit cost analysis, but it requires assumptions and being transparent about what assumptions you're making about the cause and effect chain that gets you from your action to the result that you want. So I think that's an important thing to think about when we look at that. And so yes, I do think the idea is there are different alternatives. Maybe there are different interpretations of the statute, but I think also they may be just different ways of achieving the statutory goal. Let me just, one more comment on that. Benefit cost analysis is designed to be blind to distributional effects. So I firmly agree with your approach of saying distribution is really important, but let's look at it separately rather than try to put in some weights, because that just gets hidden in a black box. It's very important, and that's what, as you say, Circular A4 says, that's what RIAs are supposed to do. And for some rules, it's the distribution effects that drive the whole thing. So this notion that the executive order or that OIRA's review is only about maximizing net benefits, the language of 12866 even says ensure the benefits justify the costs. Yeah. So.
Okay. Other thoughts?
So if I can draw out sort of one point on that first question, which I think ties into the question of how we define the baseline in a very important way. Mm-hmm. And this is sort of a challenge that I think has been identified in some of the public conversation of how we should do this. And often under A4, we adopt a sort of pre-statutory baseline. And so what you get in the regulatory impact analysis is a combination assessment of the legislation and the implementing choices. Now, to this point, at least by sort of my assessment of what I have read, at least Treasury's RIAs to be saying, Treasury has adopted a sort of post-statutory pre-regulation baseline. And I think that is exactly the right approach. And I think sort of what that does in a useful fashion here is it really focuses the analysis where Treasury has discretion and where different regulatory alternatives can give you different results. And so then you can report a bunch of different, if Treasury has the authority to do a bunch of different interpretations, you could report a bunch of different interpretations against that baseline and compare and deliver sort of really that high value analysis. By the same token, there will be some circumstances where Treasury has extremely limited discretion. And so the regulatory impact analysis will on some level be sort of constrained because there won't be that much in the way of regulatory alternatives, or the two regulatory alternatives will, basically be the same. And so you'll see that. And part of the reason I think this post-statutory construct here is the most useful one is because we'll have already seen from joint tax the necessary analysis of the statute itself. And so this really sort of allows us to, in each case, focus in on the piece sort of where the value is highest, where the transparency is highest, but it also ties into this idea of regulatory alternatives, because when Treasury has discretion to implement a bunch of different options, you can explore those different options against that baseline. When Treasury does not have that discretion, you'll sort of, you'll get one option or two options that basically look the same. And so you'll sort of naturally see that, and that the difference in statutory authority will be reflected in the regulatory impact analysis as you would sort of like.
Sure.
One of the reasons that Circular A4 presumes a pre-statutory baseline is, as we've said, there may be different ways of interpreting the statute. But a second reason is that it can be useful for informing Congress. So looking at a pre-statutory baseline can inform Congress that there's an alternative path that might have achieved what you wanted with lower burdens. So I think that it remains to be seen how this gets decided, because I think the MOA is a little bit unclear whether it is, and so I think that'll be interesting to watch.
Actually, a couple things. I guess one on the pre-statutory baseline versus the post-statutory baseline. I guess I'm familiar at least a little bit with work in like the environmental area, and so the statutes typically say something like maximize the benefits of clean air to the extent technologically possible and economically desirable. The tax laws pretty much are tighter than that, in the sense that they kind of tell you very closely.
That would be a very prescriptive environmental statute, by the way, yeah.
But they're tighter than that, and so the range for movement, I think, is somewhat narrower. And so I think Greg's point about having the post-statutory baseline is that the Joint Tax Committee's already done an estimate of what the revenues are going to be, and so that's like there already. And then you kind of build on that and say, okay, well, there are several options for Treasury to choose among, or Irish Treasury to choose among. That's the space that you'd be looking at.
Another brief comment, I promise. Often what agencies will do is look at two different baselines and do the analysis from both. And so if it's very easy to do it from the pre-statutory, it would be, well, here's what the Joint Committee said, and here's what we think on top of it. You could do both ways.
Touching?
So my sort of decision tree for figuring out this question of whether you're in a zone of discretion where optimizing makes sense or not is really you just start with a legal analysis. And the legal analysis tells you if there's a determinative outcome or there's a delegated discretion, a zone of discretion under which Treasury can choose among different outcomes. And once you're in that discretion, your legal analysis leads you to figure out what that zone of discretion is, what's legal for Treasury to choose between, and that's where you're optimizing within, and that's where the cost-benefit analysis can start to make sense. Now the thing where I think where sort of some language can make a big difference is that when we're talking about interpretation, we're often talking about a lot of different types of interpretation. One is that question of choosing within that zone of discretion, which I would not actually think of as interpretation anymore. It's really making a policy choice that has been delegated to the agency. Another sort of interpretation is figuring out what did Congress mean? And in some cases, it's going to be really, really tough. For example, where you have a law that was rushed through without very many hearings and not a lot of drafting discussion, to figure out whether or not something is open textured because Congress intended to delegate a bunch of discretion for Treasury to make a policy decision, or because they were just simply unclear and didn't have a very good drafting around a determinative outcome that they wanted to achieve. So I think that's why you sort of still start with a layer of legal analysis, and when you're doing that legal analysis, you're not doing a cost-benefit analysis to choose between them, but to figure out what your zone of discretion is.
Thanks. One thing that I think I'm taking away from the discussion is that y'all think there's a benefit, potentially a large benefit, from having Treasury economists involved in the regulatory process. Is that accurate?
Yes.
Even the former Treasury economist? Not yet. So.
I mean, I worked on the individual staff, so I mean, I think a few people here. Yeah, but I certainly think there is at least potentially value. I did sort of take one step back and pose a slightly broader question about sort of how we ended up where we are. And I think, it would have been in some sense desirable to have this event before the MOA was signed/issued, and so that we could have developed sort of a conceptual framework for what was desired to be done, to figure out really how we want this process to work and how we want the value to be added. So I certainly think there is potential for gain here, but I think we're also, the existence of this event acknowledges that we're sort of trying to figure out
We're in a post-MOU baseline.
how to achieve that gain and what that gain can be in different scenarios.
So let me add one bit to my very short yes answer, which is I think the one thing that Treasury now does not do well is estimate compliance costs that it imposes on people. And I think if there's one good thing that comes out of the MOA, it would be forcing the Treasury to do that better. And
so just to build on that about compliance costs, Do you think that the MOA allows you to, or requires you to trade off compliance costs versus revenue? So if you get an extra $100 of revenue, but it costs $200 of compliance costs?
Well, requires and trade-off. Remember, the language in 12.866 is the benefits justify the costs, right? So there's no required there. But I do think that the RIA should have that information in it.
Yeah, people say RIAs are informative, but they're not dispositive. So the RIA doesn't tell you the answer. It's a transparent accounting of the information you know about the consequences of it. One of the things that, so I've worked at EPA, and I also worked as an economist on the OIRA staff long ago. And one of the things that agencies economists will often say is the presence of OIRA gives them more clout within the agency. Maybe clout's not the right word, but their analysis is taken more seriously. And so, in response to your question about that, I think this will give them more.
One more thing, SEC has hired a bunch of economists to do cost benefit because of the business roundtable case, right? So it's forced economists to become involved in the regulatory process at the SEC, and I think that's been a good thing.
Okay. The $100 million threshold in there, is that as bright a line as it seems?
No. So, so the executive order discusses, it has several criteria. So it talks about significant regulations, and those have characteristics. I mean, non-significant regulations are really not very significant. Like I tell my students, it's like drawbridge openings and closings. That's done through regulation, believe it or not, but it's not significant. But then there's a subset of significant that is the 100 million or more, and those are called economically significant, even though that term is not really in the executive order. So economically significant regulations require more analysis than significant regulations, but the significant ones, which will have some impact on policy, precedent, et cetera, those are expected to have some analysis. But the idea is that it's commensurate with the magnitude of the issue, of the regulation, the amount of analysis.
Anything else? Distribution analysis. So Cheng was mentioning distribution analysis is almost central to the way the tax code works, and that's something you want to be put off to the side. And so if you're doing distribution analysis, then obviously, Cheng, people don't get the same weight, right? That in your example, Warren Buffett versus low wage worker would get different weights. Is that correct?
Yeah, you can probably guess, working for an organisation that tries to think about the way that policy impacts low and moderate income workers, where I would put that weighting. But as I acknowledged, it's a sort of a politically disputed thing, and there's value judgments that go into that. So I think this is one of the reasons why it has been difficult to deal with. In other areas, but in other areas there has been this additional justification for putting distribution analysis to the side of the cost-benefit calculation, because we'll take care of it when we get to tax. So I think that's really important when we're setting up any type of calculation or thinking about how we present the same information, which is actually really the difference between David and Greg here is how we sort of present the same sets of information, making transparent that this is an important piece of the puzzle.
I do agree that distribution analysis is important. I also feel strongly it should be separate. Benefit cost analysis by its nature is blind to distribution effects. But that doesn't mean that the distribution effects aren't hugely important and they're not just shunted aside to be dealt with elsewhere.
But
I think that's what we get in David's approach, is that it's one of the three pillars of his approach.
So if I can, there's I think an important question, a technical question about efficiency that is lurking under a lot of this. And I mean, efficiency, like all terms on some level that economists made up, economists defined, and we can define it in a million different ways. Traditional concepts of efficiency, you sort of often have this idea in the background that you're going to engage in a bunch of lump sum transfers, potentially person-specific lump sum transfers, and the question the efficiency analysis poses is that once you've done those person-specific lump sum transfers, then have you made people can you make everybody better off? There's sort of a challenge in applying efficiency concepts, efficiency definitions, to policies that change a federal budget balance. Because in most of the models we use to do this, budget balance is simply enforced. You cannot break federal budget balance, and you get boiled in oil if you do, or narrow audience for that joke. And so there's a risk here. The reason I bring this up here is that sort of implicitly efficiency analysis will often assume do something that's equivalent to assuming a lump sum transfer to sort of solve that problem. What this then means is if we want to do an equity analysis that is consistent with our distribution analysis, we need to put those lump sum transfers, whatever they are, in the equity analysis. This is because nothing is new under the sun, and we're, in some sense, translating our traditional tax tools into this cost-benefit framework. You'll recognize that sort of immediately as a fully financed distribution analysis. I've told you that I'm going to cut taxes by $1.5 trillion, and then people start posing the question of sort of, well, what does it look like if I pay for that? And I sort of do that in different ways. And the doing that in different ways highlights that there's a certain hypothetical element to all of this. You don't know how the offsets are going to be done. You don't know what they are. Anyways, to bring this all back to sort of the question we have at hand, if we're doing an efficiency analysis of a policy that changes the government's fiscal position, right, we are in some level on the background assuming some offsets to that. If we want to think critically about the equity or distributive impacts of that policy, then the equity analysis needs to also have those transfers in it. Of course, the problem is we, again, don't know what they are. And so this is part of what says, in my framework I say, do revenues, do burden, do compliance costs. You can think about those in different ways. It's entirely coherent in some sense to translate those ingredients into a separate analysis that's an equity efficiency analysis. Certainly the people in this room, I think, have probably heard of equity efficiency trade-offs before, right? The two things to know is that if there's a fiscal impact of the regulation or the policy change, that needs to be reflected in both of those in a symmetric way. And fundamentally, it's a hypothetical exercise in some level. So there are ways to put equity in the benefit cost. There are ways to distinguish efficiency and equity effects. But on some level, one of the most important things here is to do that in a consistent fashion. And then finally, I want to quibble briefly with the idea that benefit cost analysis, as offered in 12866, sort of has this separate equity idea. The language of 12866 certainly allows taking into account distributive impacts and equity as a benefit. And I think the conceptual framework of the equity efficiency trade-off has as a core function, if not the only function in some models of the tax system, as promoting equity. And so there's a sense in which doing a benefit cost analysis departs from an interpretation of what that ignores equity, departs from what an interpretation of the statutory framework might be sort of understood to be achieving, right? So there's that idea. If we can separate equity and efficiency, separate efficiency in various constructs, but if we do that, we have to make sure we have an equity analysis that's parallel to the efficiency analysis.
Can I ask you?
Yeah, sure.
So if I repeat the question to make sure I've got it, which is whether the distributional analysis requires weighting.
Basically.
The answer is no.
Okay. And you would just have it be a separate analysis?
Yeah, the distributional analysis is, do it deciles or whatever groupings you want to do. People in this decile are this much better or worse off. Flat out. That's all the distribution. You don't have to weight then. People then in the room or in the public can decide what their weights are and how they value that. The distributional analysis itself does not require weighting.
But does it fold into your cost-benefit analysis?
It's in the RIA, the way I envision it.
Yep.
The RIA tells you how much the regulation increases or decreases total resources available to our country. It tells you who bears the burden and tells you what the revenue effects are. And the burden piece you're asking about does not require weighting. people have different weights, and we state who is better or worse off, and then people can make their own judgments about that.
Yeah, I think the mistake we're making is we're still assuming that the only thing that Executive Order 12866 or OIRA review does is look at benefit cost analysis, and that simply is not true. And I'll just lay out food stamps as an example again. That the analysis, so food stamps definitely go through OIRA. You know, they do the analysis, and and the purpose of that is to think about what are the unintended consequences, how could we do this more efficiently, what could go wrong, and to understand assumptions, alternatives, and outcomes. And that to me is very important. And it isn't just a green eye shade, tally up the benefits in one column and the costs in another. And so I think if we can step away from that, I think you'll all be a lot more comfortable with IRS rule review.
Yeah. Looking at IRS rules, do changes in the costs of tax administration figure into this, and do they get the same weight as changes in compliance costs for taxpayers?
My view is yes.
Yes, to both?
Yes. So the government can decide to make me keep records, or they can keep records. Think about, you know, the proposals to have the government prepare returns. Right? They can do it, or I can do it. Right? Either way, it's going to cost money. Right? And it's going to. We just want to have it cost the least amount of money to do that. Right? And so money's money in that case.
And that's my core objection with the marginal revenue rule. I don't think that there's any reason to think a policymaker or the IRS or Treasury should take the position that $1 in government hands is the same as $1 in private hands, and they can be directly traded off against each other.
Well, remember, we want to say how much the regulation increases or reduces total resources available to our country, and we want to say who is better or worse off. We want that information available in the RIA so people can make judgments. We don't want to ignore that second piece, which is what you're saying we're doing.
No. I agree we want that information. And I'm agreeing that you need to present each of the pieces that you then add up to a bottom line. But I don't agree that you should be weighting revenue for the government the same as revenue, as those compliance costs for taxpayers.
You want to measure whether the regulation increases or decreases total resources available to our country. In that piece of it, you weight $1 as $1. And the other piece, when you say who's going to be better or worse off, you explain, well, in fact, you know, Joe Plumber is better or worse off because of this. But when you want to measure total resources available because of the change in total resources because of the regulation, then whether the government files my return or I file my return, if it costs $1 or $100, whatever it costs, that's how much it costs. Okay.
So I'm going to, right, right. So as a general matter, right, my bottom line is we should be doing inputs, not outputs. So in that sense, I'm not doing this weighting, and the reason I'm not doing this weighting is because I don't think Treasury should take a stance on this weighting. However, there's also a reason sort of in my conceptual framework this doesn't necessarily show up in this sense, which is I'm taking as given the legislative and other parts, or the statutory and the other parts of the regulatory framework. And part of that is, in a sense, IRS appropriations. And so in this perspective, to the extent that you create sort of new costs for the IRS that are not, manifest as sort of, can be offset with a source of revenues, or that, suddenly the IRS can set its own appropriations, you would feed that through into impacts on either compliance costs elsewhere. So there's an additional administrative burden on the IRS here. As a result, they don't do that, and that creates compliance costs, right? So you could have that channel, and you also could have this regulation in whatever way it takes place, affects the opportunities, the priorities of the IRS. And as a result, they change their enforcement strategies, they change their methods. That might also change revenues, it might also change burden, right? So in general, I'm suggesting don't do the weighting, but in the practical application to this particular question, I'm actually suggesting we do a slightly more direct analysis of how this might affect IRS behavior and how that feeds into the quantities that ultimately we want as inputs: burden, compliance costs, and revenues.
Can I? It's not your question.
No, that's fine. We're trying to have a good discussion.
So it's kind of a little bit in the weeds in the economics, but I think it's important to understand, which is what Greg is saying and what I'm proposing, I had those 3 pillars, 1, 2, 3. In fact, Greg's revenue estimate minus the sum of his burden estimate is equal to the MRR.
Almost.
No. We disagree about how you interpret the MRR, but it's
We
equal
also
to the
disagree
MRR.
about that fact.
Okay, well, okay. I think I have a write down a little model if you want. I can show you in like really simple cases, and maybe you add a bunch of filigrees and twists and turns and backflips. In a really simple case, what you can show is that the revenue estimate minus the sum of the burden estimate is equal to the MRI. So when you're saying you disagree with one of us, I think the core of what we're saying, actually stated in a different way and maybe presented in a different fashion, is economically identical for the most part, right? Maybe there's some general equilibrium effect or something else going on, but like in a simple model, what you can show, and I can walk you through an example if you want to do it a little more, is in fact the information that you're proposing be presented and the information that we're proposing being presented is actually the same.
So actually, I agree the information being presented is the same. I think we're all agreed that the input's the same. The inputs are all, it's important to have the distribution analysis there as an input. It's important to have the revenue and compliance costs and administration costs there as an input. I think the question is that when you sum one of those parts, you're embedding a weighting.
No, the weightings are the same. So again, it's unweighted. The distribution analysis just not with distribution weights, just who pays what. You add that up and you get a number as what the total burden or benefit is, okay? And you take the revenue estimate, which is just unweighted, and you take the difference between those 2 numbers and you get the MRR. There's no weighting in Greg's or mine.
There's a weight of 1 on each side.
Well, Greg would then have the weight of 1, 2, right? So the MRR is equal to the difference between Greg's revenue estimate and the sum of the burdens in Greg's burden estimate, all weighted at 1. Okay, so there's no difference in weighting even between Greg and me. Maybe there's some difference in interpretation or presentation, but we're both weighting everything at 1 there.
So I want to disagree slightly with saying that we're presenting the same thing, which is that we are presenting something that is very, very closely related, but there is one important conceptual difference, and that is my revenue estimate concept should include the impact of changing deficits and debt. When I am thinking about this question, and Treasury issues a regulation that changes fiscal balance, right? The revenues and deficits matter, and to the extent that those matter, they feed into this analysis. So there is that important conceptual difference between my revenue concept and sort of David's implicit revenue concept, and that also ties back to this question.
You're doing different revenue estimates than they do for legislation. What are you proposing?
Right. So mine is, right. It is a revenue estimate that reflects all behavior that is not future federal legislation or future federal regulation. So includes behavior, all types of private behavior, includes state behavior, includes foreign government behavior.
Right. We just said revenue estimate. Whatever they do, right?
You have this right. Or well, okay. I mean, at this point, I don't know whether you're changing what you told me before.
No, we said revenue estimates. We didn't specify what we meant by it, but we said revenue estimates, whatever that meant.
You two could write a joint paper, kind of walking between the.
Yeah, I didn't want to get too much in the weeds. I just want to emphasize that in fact the 2 proposals are far more closely related than it might
I think
seemed.
everybody agrees they're closely related, right? Chamber was basically saying that the same inputs.
I think they're the same.
And you think
weightings on.
So we wait the webinar where we get the equations and get to go through where they're exactly the same. I think one thing I'd like to sort of probe a little bit more is that in your paper's appendix, David, you acknowledge that when you do this calculation, you are whether or not you think the weights are implicitly the same in David's and Greg's approach as yours. Yeah. In your approach, you do say that we are embedding a strong normative assumption about $1 in public hands and $1 in private hands. And from an institutional point of view, I look at strong normative assumption and Treasury and OIRA, and I think maybe those 2 things shouldn't mix.
Well, remember how I'm thinking about this is the MRR measures the change in total resources available to society, so people work more or less, save more or less, that kind of thing going on. So it's the efficiency effects of the regulation. To do that, you have to have that assumption of it doesn't matter where the money is, right? But then we don't think that's the right answer for how you think about tax. We think who pays really matters. It's just that if you want to separately state the efficiency effects, that's the assumption you have to make.
Who pays really matters, but the budget constraint also really matters. And
Yeah,
to have one part of the sort of calculation that gets you to some ultimate social welfare calculation, basically make the assumption that it doesn't, I think presentationally is an issue.
Okay. Maybe we should open it up to the audience, because I think there's a lot of, yes, there appears to be a lot of pent-up demand, at least in that corner of the room, for questions. So there's a mic being walked around. If you can identify yourself and ask your question, we'll go from there. Start at the end. Start at the end. Oh,
Okay, hi.
we're in the middle.
All right. So my name is Joe Cordes, and I actually have my feet in both camps. I at one time was a practitioner of the dark arts of tax incidence and revenue analysis. I now am a practitioner of the dark art of cost-benefit analysis, and in fact, I teach a course at least 2 or 3 times a year, and I want to talk a little bit about the distributional issues, because that keeps coming up here. So, and specifically about this weighting question. So, it is absolutely true that as a tool, benefit cost analysis is first and foremost intended to measure whether something in effect is efficient, whether it achieves a potential Pareto improvement, for those of you that know what that term means, not an actual one, because there's already redistribution going on in a lot of these analyses because you have gainers and losers. So the question is sort of what do you do about distribution? It's also true that certainly in its early days, CBO gave very short shrift to the distributional side of things, saying, we're mainly about efficiency and, leave it to the tax transfer system to worry about that. I think that sort of what's considered to be contemporary best practice anymore in benefit cost analysis is, to the extent the data are available, the analysis should provide considerable detail on the distributional effects of the policies. However, as a separate kind of matter, as to this question of weighting and whether a dollar is a dollar is a dollar, David is correct in saying, in principle, you could try to weight the different amounts. The problem with that is that while that sounds like a great idea in theory, we've never really come up with good practical solutions. And one of the ones that some of the older among us might remember, which is a real hoot, is people used to say, oh, well, why don't you use the schedule of marginal tax rates to infer what society places, the weights that society places at different levels of income? I mean, really? So what are you reduced to? You really are reduced to, some kind of subjective application of the principle of diminished marginal utility of consumption. What I think most textbooks will tell you, what I tell my students when you do a cost-benefit analysis, is the initial analysis should be a plain vanilla, a dollar is a dollar is a dollar to everyone, okay? Why is that important? Because it really makes it transparent kind of what you're doing, okay? Then if you have enough information on distributional effects, you could go in and say, how would this change if we, gave Warren Buffett a weight of 1/100th of a middle class, whatever. Indeed, the Obama administration strongly encouraged the regulatory agencies to try to do this. Now, the problem that they faced, which is why I don't think you see much, is they don't actually have a lot of information in what they do about that. The beauty of the tax side is there will be a lot of information about that to present, as David has suggested, deciles, whatever. And then you can either, decide to let the decision makers and other people evaluate it, which I think is what OIRA would really prefer, because I don't know that they're quite in that game of trying to impose those kinds of social value judgments and how income would be weighted. So I actually think these are fairly compatible approaches, but I don't think CBA anymore totally, you didn't say this either, but I'm saying it's definitely moved much more in the direction of treating distribution separately, but treating it as a fairly important bit of information about whatever it is you're evaluating, if you can get it, in addition to the efficiency effects.
Any responses? Okay.
I agree.
Then another gentleman in a blazer and a blue shirt.
Len Berman. I had, 2 comments or questions about whether they would fit in in your version of the analysis. One is just in terms of measuring compliance costs. It might not have any effect on compliance costs, but it might reduce uncertainty. The law is the law, whether there are regulations or not. And one key reason to do regulations is to let people know which of the competing alternatives you're choosing. And they might be equally good. But if you're doing cost-benefit analysis, you should take credit for reducing uncertainty. And maybe you could use a risk premium or something like that as a way to estimate that. Second point is reducing evasion. I think in David's construct, if you increase voluntary compliance, that counts as a plus because that's a voluntary remit. But improving enforcement should also count. And the reason is that if you look at least in the literature on optimal evasion, the value of $1 saved in taxes to a cheater is less than the value that the reduced taxes. So if somebody's not evading all of their obligation, you could just as a simple approximation say that half of the revenue you raise from enforcement because, say, you have information returns, would actually be a net gain to society because the loss to the cheater is less than the gain to the Treasury from the revenue you're collecting. And you could actually do something like that for improved compliance, to improve voluntary compliance. Well, no, you already have that because that's in your behavioral response. But that's the sense in which improved enforcement would add more to the benefits of the regulation, or could for some kinds of regulations.
I think I definitely agree. I had not thought about the first one. It's a really interesting point about the risk premium. I agree. I need to think about it more. But on the evasion one, I hate figuring out stuff that's hard in front of a big audience. I think what you're saying is someone's kind of at a corner where they're kind of completely evading. So there's no behavioral response for that person. And at that point, and Greg pointed this out to me in an email this summer, the kind of marginal revenue rule requires optimizing behavior, and if you're kind of off the optimization, then you need to do something else. I think maybe is my response, but I'm not sure. Maybe we should, maybe not quite understanding, but we should talk more.
On the end of the row?
I'm Pete Davis, former Joint Committee revenue estimator who participated in many drafting sessions. And when I'm confident of my estimate that I've got good data in the model and the lawyers actually agree with me in the room, we draw what's called a bright line test. And Treasury doesn't have too much discretion to interpret. But there are many occasions, like for example, the Section 199A 20% small business deduction, where you're in the room. I made a lot of assumptions based on a little bit of data, and the lawyers are all over the map. And so we give a lot of discretion to Treasury. Treasury just put out regs. They didn't answer a lot of questions. So we're still wondering right now in the real world whether some multi-billion-dollar hedge fund manager is going to get a 20% deduction, or whether it's really a small business who's really going to create jobs. So I would like people to address that.
So I think there's a certain connection between that question and Lynn's previous statement on how you think about the reduction in compliance costs. And I think this also ties back to this question of what the baseline is. And if you adopt a post-statutory post-statutory pre-regulation baseline, then the uncertainty is in that baseline. And then you can think of regulations, and Treasury is explicitly talking about these concepts in their RIA. So I'm not, making things up that they should do. I'm just repeating things that they're doing that I think are correct. Is that you sort of, as the regulation provides more and more specificity, then you are reducing compliance costs in different areas. You can think of this as sort of a risk premium concept. You can also think of it as sort of number of hours I was going to pay my lawyers to write opinions justifying the thing I was going to do, and now there are fewer hours. And so you could apply that to sort of, there are 7 important open questions, probably a low estimate, and the first regulation identified 4 of those and answered those 4, and so I'm reducing compliance costs in those 4 areas. There are still 3 that are out and open questions. So I think there's a very natural sort of connection between those 2 questions, and you would sort of, as piece by piece, you'd sort of get to this. Now, I think this does, this is not what you asked, but I'll answer it anyways. This does, I think, get to the sort of biggest question about the post-statutory pre-regulation baseline, which is that when Congress enacted the legislation, they were assuming that someone would regulate. Who knows who? Someone. Right, and so in some sense, this baseline overstates a little bit the uncertainty because everybody knew there was going to be an answer. We might not know what the answer was going to be, but we knew that there would be one, right? I think this is sort of, the war on what is otherwise the best option, but it does sort of lead to some sort of, ambiguities here because Congress was assuming someone would regulate. But the advantage of that baseline is exactly, it speaks to your question, is you can sort of think about the different regulations providing certainty on the different points as you work through them.
I think I know 109A has a lot of uncertainty, but is it more than, say, the consolidated returns where the statute basically says, write whatever the heck you want for consolidated returns? I don't really know, but it would strike me sort of not out of the ordinary for the kind of delegation Treasury has.
Other questions? Okay, we got one from online audience. Said that one of the statements from the speaker said that compliance costs have only a deadweight loss, but compliance requirements such as information reporting can have real effects on taxpayer behavior, affecting both efficiency and distributional effects. And so, should we incorporate these compliance requirements and address them as part of the analysis?
Well, yeah, I mean, totally. So suppose we make everyone, keep lots of good records. The IRS can then check how much income you have. That affects how much you report, right? So that goes into both the revenue piece of it and the efficiency piece of it. But the keeping the records themselves, if they have no other purpose, is a straight up cost. Mm-hmm. So the behavioral effect of compliance, is why we have compliance costs, hopefully, not just to waste people's money. We do some of that. Is to create behavioral effects. It's reporting or behavioral effects, I should say. And so the reporting effects, behavioral effects of compliance are central to why we do it and would be included in the analysis. But I didn't mean to say there wouldn't be those things.
Okay. Any questions? One other. Sure.
I think it's an open question. I don't have a great answer for it, but there are, in terms of tax system compliance, and this sort of goes back to what you think the tax system, and Treasury and IRS are supposed to be doing. I mean, does sort of general trust in the tax code, the fact that people are sort of paying what they owe, et cetera, that probably sits into the non-quantifiables bullet in the regulatory impact analysis. It might, at some point, if we get really, really good at our sort of tax administration empirical literature, go towards a calculation of where people hit the tipping point in terms of their trust in the system, where compliance starts dropping off a cliff. But I think that's another important thing to sort of keep in mind somewhere in this soup.
Hey, Susan, I had a question for you. When you mentioned earlier one of the roles of OIRA is to do the interagency coordination. Does that open up the risk for the tax regulatory process being politicized in the sense that the National Economic Council at the White House has a role now in the regulatory process that they didn't have before?
There definitely is an element that the White House is involved. And I think an argument for that, in favor of that, is that if there are policy issues to be resolved, the President of the United States is the only elected person. So he is accountable, he or she is accountable, and if people don't like those policies, can be voted out. Whereas you can't vote out people who are putting weights on something, a tax analyst in IRS who's putting weights on something if it's not transparent.
But you are trading off that expertise versus not.
Well, I mean, I think you still have the expertise, but that's right. And that's true with everything. And you do see different administrations will come up with different policies with the same analysis, with the same data. And in my time at OIRA, there were some times when I felt that the White House told us to do something that was different than what the analysis would have led us to. And but it was rare. It was more rare than you would think.
Interesting, good, because it's actually a worry I had about the MOA, which is, you've got a constituency who's going to be hurt by a regulation, but so is everybody else, but this constituency has the president's phone number. Right, and then the question is what does the White House involvement in these regulations do to the, you think everyone should bear the same cost, but this one group gets out of it because they know the president, and that strikes me as a real cost to the MOA. But you're saying, in your experience,
One of the advantages I think of OIRA is that staff, it's a small staff, and they really do have the more cross-cutting view. So they're not as myopic. They're not as susceptible to special interest pressures. Now, within the White House, there's the National Economic Council, Domestic Policy Council. They also tend to have cross-cutting perspectives. You also have groups that have very narrow focus. Right now, the Trade Council. And to me, it's those with the narrow focus, which can be an agency. It can also be a part of the White House that might have that, and that's the bigger concern. But I think the OIRA review itself tends to step back and allows you not to have that tunnel vision to see the consequences more broadly.
because it might depend on how strong the OIRA administrator is versus other people on the administration.
I mean, one could also make the opposite argument in theory that folks in OIRA, especially if as they staff up in tax, they take the same approach. If they have a broader view and are sort of less in the technical weeds of things, then potentially interest groups are more likely to be able to get one over on them, as opposed to, and some of these things look very technical and are very technical on a sort of first blush. So, there's a balance of those two things, and I think Len wrote a blog about a week ago or so with his question posed at the top: is this sand in the gears? And I mean, I think the reporting that we're seeing is kind of what you expect. The lobbyists are treating this as a second bite at the apple, and you can argue about whether or not that's a good thing or a bad thing, depending on your position on whether or not that's a sort of a net cost or a net benefit, having a different and less technical potentially and more a broad-reaching view as part of the process.
Can I just make if we have time, 2 points just about how OIRA review does work. OIRA doesn't have the final say. So OIRA review, the final rule is a discussion, and it doesn't have the final say. So it still would be the agency's regulation. Also, OIRA, the process for meeting with people outside is very limited. So it is when a regulation is under review, then as a member of the public or Congress or something, you can reach out to OIRA and you can have a meeting. And OIRA has a policy, where they will accept meetings from whoever asks during that window, but not before, not after. And it is transparent. You can go onto the website and see who they met with, when, the topic of the rule, and if there was any material delivered, that's publicly available. So it's actually a very transparent process. So I think, again, that's another reason why it's less susceptible. Now, that doesn't apply to the NEC. If somebody else, and I'm not picking on the NEC, you said, I don't really know
I used to work
anybody
there,
there.
so you can pick on it.
Yeah, okay. Mark says it's the NEC, but I mean, they aren't subject to the same constraints, but.
And if I were to sort of put a dollar on the sort of ratio of industry groups that we see on that list, as opposed to lobbyists for low-income people over time,
but that is a decision, because that's something I hear in the environment area too. But there's no reason whatsoever that anybody who wants to can't go in.
Other than resource. Other than resource.
Well, yeah.
Question in the back? You have a microphone right behind you.
Monty, wait, there you go. Monty, say your name.
What?
Say your name, Monty.
Monty Giaco. Thank you, David.
We're old friends.
There's a fair degree of obscurity in terms of how, I can't even say OIRA. OIRA.
O with an IRA.
O with an IRA. Okay.
Nice job.
How, for example, there's a couple of parts of this question. First, does anyone think that any input that the White House has in reviewing the reg, and making comments and changes, just like the reg preambles mention changes made in response to commentators to the reg, should that be disclosed, or is that going to be shrouded in secrecy? That was part one. And second part is, I'm not aware of any governing procedure dealing with, for example, the definition of what's economically significant in terms of flushing that out, or what's a novel regulation, or what's unique, and whether that will be disclosed. So far, I haven't seen that. So I'm more interested in the practical aspects, and what if there's a disagreement between the agencies, and is that going to be public or private, or should it be? And that's about.
Okay, I think
Any responses?
so.
Sure, okay.
To the first question, you can get a copy of the rule as it was submitted, and obviously you have a copy of the final published rule, so you can get a red line. So yes, so that's transparent. It's not just posted on the website, but you can ask and get it.
Are you saying that Treasury will hand over the?
No, OIRA will.
So you get the regulation that went to OIRA, and you can compare that to the
Yeah,
final
and
regulation.
I think what you get is a red line.
Oh,
So you'll
interesting.
get a red line. It's on request. So it might be worth doing that just to see what's going on. Let's see, your second
Mine has got a
question.
secretary now. Every regulation is going to be requested automatically, right?
So far, only 7, so it should be an easy thing. So your second question was, yes, there are definitions of what's significant, and I should know. I think it might be, yeah. And these are things that are discussed between the submitting agency and OIRA. Under the executive order, it's OIRA that has the last word.
But it's not disclosed in the, up to date, it has not been disclosed in the regulation preamble.
Well, you know which regs are submitted, right? You know which
Yeah.
ones aren't.
Yeah.
But I don't know. It's
don't know why, you mean?
you look at it, and it'll tell you, the website would tell you whether it's economically significant or not. And that's all it's going to tell you. And then you can draw your own conclusion as to why else it's being reviewed so far.
Yeah, in the preamble to the rule, there should be a description. There's a section that says, we've decided this is significant under the executive order. It usually explains why. So there should be a couple paragraphs. Yeah. And have you seen rules that you think wouldn't meet any of the criteria? And maybe it's meeting several.
Unless I assume that every single regulation under the TCJA is novel, presents novel legal issues, there's no explanation for why it was reviewed by, how do you pronounce it again?
OIRA.
OIRA.
Yeah, and I'll just go back to a comment that I made earlier, that the rules that are considered non-significant, they tend to be really non-significant. So the drawbridge openings is an example. And you had a third part to the question, and I forgot it.
Well, I think it was in terms of, what if there's a disagreement between the agencies?
On whether it's significant, yeah. Under the executive order, it's OIRA that makes that decision.
Okay.
Okay, one last question there, or comment from Joe. A quick one? Yeah.
Elaboration on this. Okay, Susan, you may be able to correct me on this, but I think you can also, you may have to ask for it, but you can also get lists of who was at these various meetings, right? Because I've just seen that with, so for example, some of you have heard about the public charge proposal in DHS. So there's a whole enumeration of all of the meetings, because that's gone through OIRA. So you do, and the materials that were submitted for those meetings. Now, I guess you probably have to ask for that, but
No, that's on the website.
It's on the website,
And it's a
so,
good point,
okay.
Joe, because then it gets back. So if NEC was in the meeting, they're listed too. So it's not just the people from the public who attended, but it's with the staff within the White House. And the other thing I should have said is the agency whose rule it is always invited, and most agencies always send someone. There are some who don't, but so that's, and the meetings tend to be a half an hour, so it really isn't that heavy a lift. So you go in, you have a half an hour. The OIRA staff, I've had people say, we don't know how to do those meetings because they just stare at us stony-faced. That's their job. Their job is to listen, but not to tell you anything about what's in the regulation. They're learning from you, they're not sharing. So.
Okay, well, join me, everybody, in thanking this great panel today. It was very good. Thanks a lot. Thank you.
Fun. Do we just leave?